Hello and welcome. Thank you for joining me today from wherever you are. My name is Mariah Hogan, and alongside my mentor, Professor Claridge, I have a presentation for you today concerning something that is both very familiar to all of us by this point, as well as is something that may be unfamiliar to many of you listening, being the exact legal avenues that may be available to pursue in the interest of answering the question, can he do that? That we may find ourselves asking when we see things on Facebook or the news, or even in our real lives where it seems like others are not respecting the safety protocols, the social distancing, stay-at-home orders in the same manner as everyone else is. So to put us all on the same page to start with, as we all know by now, on March 23rd, Washington State Governor Jay Inslee enacted the first in what would become a series of stay-at-home orders in the interest of preventing and containing the spread of COVID-19 through our communities. Specifically, this order restricts the ability of civilians to leave their homes for any purposes aside from the following exceptions, being pursuing an essential activity, getting takeout food or food deliveries, going to work at an essential business, or going outside for walks and exercise, certainly as long as social distancing protocols are observed. Now, if you have a pessimistic tendency at all like I do, you probably upon first hearing the news of these orders wondered, well, what happened if we don't? And we certainly have seen our fair share of violators to these and other similar orders across the country. Significantly in Washington State, there was a protest on April 19th against the governor's orders, which saw hundreds of Washington State residents in attendance. Ordinarily, we might expect the, quote, remedy solution for this type of disregard for gubernatorial orders to come from governmental interference. And to be fair, in many counties, we have seen this happen, with some jurisdictions offering fines or even threats of jail time for violators of these orders. However, at least in parts of Washington State, this hasn't been the case. In fact, there have been several counties that have outright refused to either enforce or abide by the governor's orders. Examples of this include Franklin County commissioners voting to reopen businesses as early as April 21st, 2020. As well as sheriff's offices in Franklin County and Snohomish County refusing to observe and enforce orders. So at the conclusion of this, we have a problem, don't we? Now, not only are we seeing people violating gubernatorial orders at an individual level, but because we're also seeing it occur at a governmental level, the ordinary enforcement and sanction by law enforcement agencies that we would regularly expect to be there isn't. And since we don't have a criminal avenue to pursue in many cases, we'll find ourselves necessarily entering into the realm of civil litigation in order to seek remedies beneath a theory of negligence for stay-at-home order violations. And I'm going to take you next through exactly how it is I believe we can succeed in doing this beneath the specific facts and circumstances surrounding COVID-19 and the violation of stay-at-home orders. First, it is important to have a basic understanding of what the civil tort of negligence is all about. In civil law, negligence is defined as a failure to behave with the level of care that someone of ordinary prudence would have exercised under the same circumstances. At its core, what the definition of negligence tells us simply is two things. First, that there is a standard of at least reasonable care that is expected for us to exact onto one another through our actions. And second, that certain actions have an accompanying degree of foreseeability that harm could result onto another. And negligence holds us to be able to make that recognition. In order to successfully litigate a theory of negligence, there are four factors that the plaintiff must prove against the defendant: the existence of a legal duty, a breach of that duty, sufferance of an injury, and proof that the breach is what caused the injury to occur. I will take you through each of these four elements to demonstrate how a victim of violation to adhere to stay-at-home guidelines might be able to earn success beneath this theory. First, the plaintiff will need to prove that a duty existed between themselves and the defendant. In civil law, there are any given number of legal duties. Some are specific to the type of relationship you have with another person. For example, as your doctor, I might necessarily have a different duty to you than I would as your neighbor or even as a passerby on the street. However, these can also result simply from the virtue of your own personhood, meaning that there are certain things that we expect from each other, that we should be able to expect from each other for no reason other than the fact that we are each people. The idea being that people, on the virtue of their personhood, deserve better. And so at its core, that's what duty comes down to, the responsibility to others to act according to the law. And as I mentioned before, there are several different types of duty. However, for the sake of this presentation, I've chosen to focus specifically on the duty of care. The duty of care is one of those duties that exists between two people, really on the basis of their shared personhood. The duty of care exacts onto us a requirement to act towards one another and to the public with the watchfulness, caution, and prudence that a reasonable person in these circumstances would. So when considered alongside the fact pattern of COVID-19 related stay-at-home orders, I've converted these two characteristics into really the two questions that I believe need to be asked and properly answered in order to properly litigate a negligence tort in this case. Being first, would a reasonable person violate gubernatorial orders to stay at home? And further, is there a foreseeable risk of infecting others when violating orders to stay at home? In the interest of our plaintiff here, I think we could easily arrive at the conclusion of the answer to each of these questions being yes. A reasonable law-abiding citizen, such as the one we are alleging the defendant not to be, would not violate gubernatorial orders to stay at home. And further, given what we have learned from the WHO, the CDC, and other public health authorities over the past couple of months, there certainly is a foreseeable risk of infecting others when violating orders to stay at home. Now that we've identified the duty implicated in this case, we next have to define the breach. In arguing a civil tort of negligence, I think there's two ways you could attempt to identify breach, depending on the facts of the case. The first of which is breach by unreasonable conduct. Here again, we see the words reasonable and foreseeable arising, and that's what breach comes down to as well. Were the consequences foreseeable, and given that they were, such as in the case of violating stay-at-home orders and perpetuating the spread of COVID-19, is it reasonable to have acted in this way nonetheless? In other words, is it a foreseeable consequence that I could get someone sick by refusing to stay at home? In this case, as we know from the science and research that has surfaced through the media, it is. So knowing that, is it therefore reasonable for me to violate the stay-at-home orders? Here again, I would say for the sake of this argument that no, it's not. Therefore solidifying the argument for breach by unreasonable conduct. The second way that I believe you could go about finding breach beneath a civil theory of negligence would be improving breach by rebutable presumption of unreasonable conduct. This is certainly a mouthful, but it's not too far off from what we've just talked about. Essentially here, we're adding into the finding of breach of unreasonable conduct that conduct specifically was of a type that should create a presumption of unreasonable conduct. So to break this down, this argument is saying, given the legitimacy of the governor's position, as well as given the understanding that his orders and recommendations are going to be made in the interest of our collective community health and safety, and even further, given that these orders, by their very nature of being gubernatorial, are meant to be followed compulsively rather than optionally, we can therefore be allowed to presume that any such conduct that goes against the nature of the governor's orders is unreasonable by nature. Certainly, I think this would be the slightly more difficult argument to win, but I would be interested to see how it would play out in actuality if ever it did. The next thing we're going to have to do is connect the unreasonable conduct we're alleging with the injury we're looking to justify. Given that we know what we know about the way COVID-19 spreads, namely that it is on a person-to-person or less commonly person-object basis, we can conclude that if I get sick with COVID-19, it's because in one way or another I got it from another person. Certainly, the nature of COVID-19 and viruses generally yields a considerable hurdle to overcome in establishing causation, partially owed to its invisible and intangible nature. Efforts are being continually made by the CDC, the WHO, and others to create a contact tracing program suitable to contain and inform the spread of COVID-19 through different communities. At its most basic, COVID-19 contact tracing would look like this. if I go into the hospital showing symptoms and I'm sick, they'll start working their way backwards off of who I've interacted with lately, who could have been exposed to the virus, and who could have exposed me. From there, we continue working our way backwards and backwards and backwards until we find exactly where it is that the virus is spreading so that we can pump resources and information and awareness into this specific pool in the interest of being able to reduce the perpetuation of its spread. Now, you might be thinking that that sounds a little bit too specific for the much more hectic manner in which viruses are spread, and you'd be correct for that. Luckily, the law allows us to prove causation in another, less direct manner by proving multiple causation instead. Like its name implies, multiple causation refers to an event that has not just one, but several different causes. The only real caveat here is that in the same way you would have to find under a standard showing of causation, you have to here prove the event or behavior or conduct you're alleging was the proximate cause of the resulting injury. So the old case that they often use to teach this concept in law school works like this. There was an engine company, and they had two different engines on two different ends of their property catch on fire. And so slowly, but also rapidly with time, these fires converged until they created a big fire. And this big fire ended up converging on a neighbor's property and completely ruined it. And so basically what this case said was that even though the exact cause of the fire was this property fire was this combined fire, that since it originated with these other two specific fires, that it was the fault of the engine company that this property was destroyed. So when applied to the fact pattern of COVID-19, I think that this makes more practical sense. For example, if I go to Walmart today and go on my monthly grocery run like I'm supposed to and get exposed to someone with the virus and get sick, it may not actually be the fault of that specific person. We know that among other things, COVID-19 has observed long latency periods where there are little to no visible symptoms. So someone perhaps had been leaving their house and going out for non-essential purposes, got someone sick who got someone else sick, and on and on and on until it worked its way to me. That is who I would be interested the most in finding for this kind of a purpose, and this type of character is what multiple causation most effectively, I think, serves to secure justice from. Once you've managed to establish all four elements of negligence, duty, breach, causation, and injury, which of course I didn't talk about specifically because certainly that aspect would vary on a case-by-case basis depending on the type and severity of the injury suffered, you'll at last be able to seek damages. And damages work as compensatory relief awarded by courts for defendant's injury against the plaintiff. Most commonly, this is awarded in money, though certainly there are any given number of things that I suppose you can be awarded. For the sake of today's presentation, I'll mostly be speaking of monetary awards of damages. There are three categories of damages that you can seek to earn. For the purposes of this fact pattern, I would be most inclined to believe that compensatory damages and general damages are the ones that you would most be able to seek. Punitive damages are probably going to be much less common in COVID-19 type cases, though I suppose that there's a case for everything. Perhaps in cases of very extreme showings of negligence, maybe. But in the interest of compensatory damages, these are the ones we most readily think of in personal injury. This is, you get hit by a car, you have to go to the hospital, so the driver should have to pay for your hospital bills and costs. CNBC released a report that shows that the average cost for a non-hospitalized patient of COVID-19 is around $2,000, while that cost increases drastically to around $30,000 for patients that become hospitalized that may have to use a ventilator, etc. So certainly these types of damages I very easily think that you could be able to earn in litigating this type of a case. General damages are a little bit harder to conceptualize. These are damages for things that are less tangible and immediate than medical bills. These are damages for things like pain and suffering. This is when you would talk about the loss to quality of life that you're suffering as a result of, losing your arm in a motor vehicle accident that makes you now unable to hold your grandkids, things like that. I certainly think that, we've seen all sorts of different survivors of COVID-19 with all sorts of different qualities of life. And I do think that many could seek to earn general damages for those types of things. Punitive damages are more in the interest of punishing the defendant. This would be, charging a very exorbitant fee for them to pay, not necessarily because it goes to cover any direct cost incurred, but because it's meant to punish the defendant for their actions. Again, I'm sure that this could come into play in cases of COVID-19. I would just say I find it a little bit less common. So at the very end of all of this, I would say the greatest takeaway we should have is simply to care for each other, now more than others. While I could spend all day showing you where the legally binding duties of care we owe to one another arise, it is simpler to say that we just should care. We should care for one another by staying home when we can, but by following the proper protocols and guidelines for keeping ourselves and others safe when we do go out. I appreciate the law for the ways in which it is able to provide remedy and justice to those who've been cheated these before. But I also envy slightly the kind of lives we could lead together if we didn't need a mandate or a term to tell us to look after one another. But until that day comes, wash your hands, wear a mask, stay 6 feet apart, stay home if you can, stay home, stay healthy, take care of each other. I think that now more than ever, COVID-19 and this virus and the social distancing protocols have really showed us that it's through each other that we're able to make the most change, and it's through each other that we're going to have to rely on the most in the coming days and weeks. Thank you for your time and attention, and I hope that you all stay safe out there.